House Bill 3020 met a couple times in the interim, took public testimony for hours. People on both sides of the issue and in the middle of the issue, all around the issue. After that, we took it to a vote in our last committee hearing. It was amended to put it back to the original version that was filed in the House. And that's where we are today, Mr. Chairman. It's the House Bill H3020 as introduced to the House. That's where it stands for our committee.
Thank you, Senator. So the report we have from the subcommittee is to address 3020 as originally introduced in the House. The recommendation of the subcommittee with an offered amendment is to take it back to this original form. So you had able assistance from 6 of our colleagues in the subcommittee. More than happy to hear from each and every one. Or other members of the Senate might have questions of the chairman or the members. I think the senator from Charleston first, and the senator from Anderson, junior senator.
Can we just, for the education of the body, explain the amendment that was offered and adopted?
Yes, it put the bill back to how it was originally filed in the House.
And so, and I appreciate the brevity, but could somebody walk us through what was amended? We're here at full committee, and if it's a senator from Anderson, I think that all of the members deserve to hear how the bill arrived from the House is not what we're taking up today. What amendment was offered and what amendment was adopted? That's just a question.
Sure. Well, the senator, junior senator from Anderson, you all sitting side by side. Senator Cash, I believe you authored and originated the amendment subcommittee, so we're yours.
Mr. Chairman, I do have a written statement I'd like to read, just to be concise and to make sure there's no misunderstandings of what I have to say and why I offered the amendment. The amendment it is an amendment to remove what would be exceptions to allow abortions for women who have experienced rape or incest and become pregnant as a result of that. So that was added into the House bill and the Judiciary Committee in the House. My amendment simply removes the language that added those exceptions and returns the bill to the original language that was filed in the House prior to that amendment. And I would like to go ahead and read this statement if it's okay with you, Mr. Chairman.
Fairly brief, not multiple pages. Sure. Absolutely.
Thank you, Mr. Chairman. I will begin by acknowledging what we all know to be true. Rape and incest are horrible crimes and cause great pain and suffering. Also, it is certainly understandable that women that become pregnant as a result of such crimes might not wish to carry the baby to full term. Such a pregnancy is a terribly difficult and unfair situation for any woman to be in. However, there are other considerations that should be acknowledged as well. The first is that killing the unborn baby will in fact end the life of an innocent human being. That baby is just as much a human being as any other baby and just as innocent as well. So if you vote against this amendment, you are voting to allow the killing of a tiny unborn baby for something he or she has nothing to do with. Second, killing the unborn baby does not undo the trauma and violence of rape. Abortion, killing the baby, is itself a destructive and violent act, and two wrongs will not make things right. Finally, in the case of incest, allowing the little boy or girl to be killed oftentimes helps cover up the crime. I wonder how many times a man has committed incest and coerced a young woman to have an abortion, thereby covering up his crime, perhaps allowing it to continue. When a woman becomes pregnant as a result of rape or incest, there are no easy answers to such a situation. But I do believe that there are right answers concerning the new life within her. In addition to what I've already mentioned, we must take into account what our Declaration of Independence calls unalienable rights, God-given rights. An unalienable right is by definition a right which cannot be taken away. But that is exactly what exceptions for rape and incest does. It takes away the right to life, which is the first and most important right of all. I think we all agree that the state does not have the right or the authority to take an innocent life. That right is God-given, unalienable. But what we need to recognize in this matter is that neither does the state have the right or the authority to give anyone else the right to take an innocent life. Any woman who has been the victim of rape or incest deserves sympathy and support. If in addition a pregnancy results, it then puts a very human face on what we are discussing, which might otherwise seem to some people to be a theoretical discussion divorced from the harsh realities of life. What I hope you realize, however, is that there is another human and another face present in such circumstances. Unfortunately, that face can be seen only on an ultrasound. Because that person has no voice and is not yet known to us, they might not seem very real. It is easy to regard the unborn person as something of a shadow, lacking in significance. And yet all of us were at one time that shadow, that unborn baby nestled in the womb. Fortunately, there are many people alive today who were in fact conceived in rape or bore a child conceived in rape. And some of them have stepped forward, put a very real face, and add their voice to the subject at hand. One such person is Rebecca Kiesman. If you were there at the subcommittee hearing, I'm sure you remember Ms. Kiesman, founder of an organization called Save the One. She herself was conceived in rape and travels the world to defend the right to life of people conceived in rape or incest. You can find similar stories of South Carolinians on the website of Personhood South Carolina. Ashley Lawton, who was conceived in rape. Rose Duncan, who became pregnant as a result of rape and calls her son the greatest blessing of her life. I'm not saying that there's anything easy about these circumstances, but I do believe there are answers that are life-affirming and life-redeeming. And our laws should protect an unalienable right to life of the least of these, even in the hardest of circumstances. I understand that this is an uncomfortable vote. Even if you agree with everything that I have said, it is uncomfortable for me as well, for the obvious burden it puts upon a woman through no fault of her own. But there are times when no course of action comes without discomfort. In this case, the other choice is to allow the killing of an innocent person, which I cannot agree to. On the subject of making an uncomfortable vote, I will offer a brief analogy. Please keep in mind this is an analogy about making an uncomfortable vote, not a comparison of circumstances. Imagine for a moment you are a juror in a capital murder trial. The accused has been found guilty beyond a reasonable doubt and the prosecution calls for the death penalty. Perhaps the case involves a particularly heinous crime such as a shooting at a school or church. Now, even if you are personally ambivalent about the theoretical rightness of the death penalty, you now have to make a life or death vote. In such a circumstance, I can imagine people might be uncomfortable about their vote, even if they are persuaded that it is the right thing to do. They are uncomfortable, but they have to make a decision. They have to do their duty about what they are convinced is the right course of action. In closing, I will know that there might be some here who choose to vote against this amendment on the grounds that it will make the bill harder to pass. There is no doubt that this amendment will make the bill harder to pass, particularly if people justify their vote against it on such grounds. It is a self-fulfilling prophecy. If you agree, even uncomfortably, in the rightness of the position I have articulated, then I appeal to you to cast your vote accordingly and help South Carolina establish a standard of justice that protects the right to life of every person, even the person conceived as a result of rape or incest. The amendment that I have offered returns the bill to its original language in the House. Mr. Chairman, I move for favorable adoption of the amendment.
Mr. Chairman. Point of order.
Stage point.
There is no amendment before us right now. The bill is before us as
Well, we're considering the report of your subcommittee.
I just want to make it clear that it's report as is.
Senator from Charleston.
Mr. Chairman, can the senator from Anderson mention two exceptions, rape and incest? As the bill returned from the House, there was also another exception for the life of the mother. So there are at least three exceptions as it returned, as the bill was sent to the Senate. Your amendment excludes rape and incest, but leaves intact the life of the mother. But the amendment that now has been adopted curtails, as I understand it, a physician's ability to determine the life of the mother, or what's at stake with respect to her life. Can you explain in your amendment what the amendment does, the restrictions placed on a physician? And by the way, these physicians will face criminal penalties. In other words, go to jail if they don't follow the amended version of the bill and walk through the particulars in subsection B of your amendment. Can you explain what you did with that particular subsection B of your amendment?
Mr. Chairman, I believe the amendment simply returns the bill to its original language. Mr. Hogan might be able to help with that, but I don't believe it is in any way affected the emergency condition that you're...
So your amendment does not place any additional restrictions on a physician's ability to make that medical determination for the life of the mother.
That is certainly how I asked the amendment to be drafted, to simply remove the rape and incest exceptions, and I believe that's how it was drafted.
And so, just for the record, a physician who performs or induces an abortion or a pregnant woman based on the exception in subsection A shall make written notations in the pregnant woman's medical records of the following: the physician's belief that a medical emergency necessitating the abortion existed.
Senator, that first amendment is actually a subsequent amendment that's going to be offered by the senator from Beaufort. The language from the subcommittee is about 10 pages in. 1, 2, 3, 4.
That statement he just read is actually on there. He's reading from the right.
My apologies. Sorry. Continue.
Just so, and I'm perfectly happy for the staff to read it so I get it right. And Mr. Hogan, would you like to read the appropriate subsection that I'm referring to? And I'm done, Mr. Chairman. I'm done after this. I think it's important that we walk through what we're voting on. We're talking about jailing doctors. We're talking about taking away an exception for rape. We're talking about taking away an exception for incest. And so we're not going to rush through as we did to get this bill where we are today in off session. And so with all due respect, I'd like the ability to, for all of the members to really fully digest. And we'll move on. I'm not trying to intentionally delay, but I think it's important for us to walk through these particulars. And if you have the votes, you have the votes. So, Mr. Hogan, would you read for me the what the requirements are for a doctor to document in the record that the life of the mother is at stake?
Yes, sir. Yes, sir, Senator. I'll be reading from 44, section 41.710. 41.700, which is obviously the previous section, does not apply to a physician who performs a medical procedure that in reasonable medical judgment is designed or intended to prevent the death of the pregnant woman or to prevent a serious risk of the substantial and irreversible impairment of a major bodily function of the pregnant woman. B, a physician who performs a medical procedure as described in subsection A shall declare in written document that the medical procedure is necessary in reasonable medical judgment to prevent the death of the pregnant woman or to prevent a serious risk of the substantial and irreversible physical impairment of a major bodily function of the pregnant woman. In the document, the physician shall specify the pregnant woman's medical condition that the medical procedure is asserted to address and the medical rationale for the physician's conclusion that the medical procedure is necessary to prevent the death of the pregnant woman or to prevent a serious risk of the substantial and irreversible impairment of a major bodily function of the pregnant woman. C, a physician who performs a medical procedure as described in subsection A shall place the written document required by subsection B in the pregnant woman's medical records. For at least 7 years from the date the document is created, the physician shall maintain a copy of the document in the physician's own record. Mr. Chairman, the amendment was strike and insert. So some of the language was repetitive in that it dealt with the life of the mother. That was stricken, but yet it was reprinted in the amendment. And only the net change, the delta of those two documents, dealt with circumstances of residence.
Senator from Williamstown, Clarendon. Sorry, Senator.
Thank you, Mr. Chairman. First of all, for my clarification, now the bill that passed the House did include exceptions for rape and incest. And so the amendment that was offered by the senator from Anderson puts those exceptions back into the bill, where there will be, so there will be no exception, even in the case of rape or incest.
Yes, sir, that's correct.
So, of course, I assume most people know that I'm actually pro-choice. I don't consider myself for or against abortion, but pro-choice. And so the senator from Anderson, in his statements, he mentioned a couple of cases where women gave testimony during the subcommittee of why they chose to not have an abortion or to have the baby. And as I said before, the beautiful thing about that is that they had a choice. But what the senator from Anderson did not mention is that we also had some very compelling and some very sincere testimony from mothers or from ladies, I would say, who chose to have an abortion. And see, we can't paint all of these situations with the same brush because all of them are different. And we can't sit at that kitchen table and know all the things that are going through that woman's mind when she's trying to determine what's best for her and the unborn child. And so, you know, a lot of us are okay with choice in this situation when the choice is one way. But when the choice is the other way, we don't think women can decide or can choose what's right for their body. And so as I sit here and observe, with one exception, none of us can become pregnant even through rape or incest. And so I think that really is being very hard on a woman to say that, you know, you were pregnant as a result of something as ugly as rape or incest, but you have to have that child. And I have heard through no subcommittee testimony, nor have I read anybody to say what kind of effect, even psychological, would be on a child when he becomes a certain age and realize that his father raped his mother and that's why he's here. Or when he realizes that his uncle is his father. And so we need to look at what that situation does to a young child in their mind. And you know, it's just hard for me to believe that, as I said before, being the pro-choice person that I am, that we're going to tell a woman that you are pregnant, even if the child is conceived, as I said, through rape or incest, but you have to carry that child that you may not want because of the circumstance for 9 months, and then you have to raise that child, which some people can do that without any problem, but for others it's going to be a daily reminder of an ugly incident in their life, that I was minding my business, going about my life, and somebody raped me, and I became pregnant, or a close relative had sex with me, and I became pregnant. It's a daily reminder. And so some people can cope with that, and some can't. But by passing the bill, we're going to say we don't care whether you can cope with it or not. You have to go through this in your life. And that, to me, is just, you know, a hard burden to put on a person, especially those who are not prepared to deal with it. So I think potentially we could have these mothers and their children messed up psychologically for the rest of their life.
Senator from College.
Thank you, Mr. Chair. I was one of the persons that sat on the subcommittee, but unlike a lot of the other folks on the subcommittee, I was actually the subcommittee chair for personhood. And my experience in handling the subcommittee hearings for personhood was we were very exhaustive during session on making sure that the public had an opportunity to weigh in, and we did not limit them like we did here. And because it was such a very important, we started early enough in the session, had all of the hearings, and made sure that we had accommodations and they were set up properly so that people that were traveling from across the state could come and weigh in. That wasn't the case here, and I get it, but I don't want the public to be misled, as oftentimes that happens. I think, as I've only been in the Senate 5 years, and I've been misled sometimes by what I see on TV or what I hear from people. Don't be misled that you think that anything that we do here is going to make a difference to this bill getting to the floor in some form, because I've got to commend the Republican Party, because they've been pretty good at saying, hey, when they get their marching orders from the other red states, they move forward on it. Unfortunately, this marching order came outside of where when we were in session. The marching order came when the other red states, deeply red states, were successful in passing this fetal heartbeat. All before that, it was personhood. Every year it changes, even though we still haven't done anything on education. Even though we haven't done anything on mental health counseling. That's not a component of this incest exception, or rape exception. What we did was we wasted taxpayer dollars for the first month of the session waiting on the budget to be passed last year. We could have had these hearings then. We were in session, we were paid, and we were here, sitting here. There's not a senator up here that can say that we didn't have a lot of downtime that first month we were in session. What we did was we waited until other states around the country passed this, and then we picked up the mantle, and the Republican Party continued it. Then we recessed on a sine die agreement. I have no problems with coming back to Columbia for an emergency. They came back on the Santee Cooper, Dominion Energy, and SC issue. We have an emergency, yes, we have an emergency regarding education, but yet we're taking the lead from other states. We're buying problems. And you know what? I know there are a lot of freedom of information requests. The freedom of information request needs to be how much the Republican Party, with this leadership, is requiring that we get paid by the state of South Carolina for coming up here in these off-session times for something that's not an emergency. We could have done this in January, and it still could have hit the floor. But I'm here. How much money? I know each time they've had to have me here, it's $200 and something. Just, now multiply that by each of the senators, it's different depending upon your traveling time. It's only to pander to a few, and I'm sorry, I'm just not gonna be a part of the subterfuge on a few. So don't get your hopes up if you're a no vote. Don't get your hopes up if you're a yes vote. It's still gonna be a fight on the floor. Because you know what? I'm the only woman that's here. With a lot of people that aren't women telling me what I need to do with my life, it's gonna be a fight. I'm not gonna pander. I'm gonna be respectful, but I'm not gonna pander. If you really believe in fiscal accountability, then why are we here and then bringing a couple of other committee meetings just to make it look good? I can't be a part of that. Thank you.
Any other senators want to address 3020? Senator Redstone.
I have a question. I did not serve on the, thank you, Mr. Chairman, did not serve on the subcommittee, but I listened to some of the comments that was made as it relates to having no choice at all. What did the subcommittee do in terms of those individuals who are mentally ill and find themselves in those two situations and have been raped or incest? Early on, we just approved 2 individuals to go on the special needs board. And I know when we went through a couple of years ago, looking at trying to fix the special needs board, there were some cases out there where some special need children had been raped. What did the committee do in terms of addressing those with those kinds of physical and mental challenges, as well as those who can't defend themselves or fend for themselves when those situations actually occur?
Any member of the subcommittee, Senator Sparkler, want to address the question?
I'll address it. Senator from Richmond, that did not come up. But really, the only thing that came up was the child. That's what was focused on, saving that child's life.
Well, maybe it should have come up, Senator, for this particular reason. That person who is mentally ill could have been raped by another mentally ill person, or the person who has a physical handicap could have been raped. And we saw in some cases, I think over in Sumter County was a case, could have been raped by someone who actually worked at the agency. I think most of what the statistics show that you've got probably maybe a 70-50 chance of that child either becoming another special needs child if it's mentally handicapped, a mental ill, or a person raped by another mental ill person, most likely again to be mentally ill or have some real challenges down the road. It's not an open blanket that says this situation fit all situations. We're already having enough challenges trying to fix some of those issues in the Department of Correction. Department of Correction itself has become the holding place for those with mental illness and having those challenges. Disability and special needs, we're now trying to overhaul that entire system. That system is broken. And so we didn't fix the law that says we're going to even compact this problem even more because we didn't consider that. We considered the situation that it fit all situations. Really concerned about what we're saying to the public. Also concerned about where we have begun to spend dollars to meet those challenges. It's a real issue. And so I'm really concerned about putting this in place without really having some real considerations. And then what we're telling those agencies that we have to fund, that right now we're not able to even fund them at the level with the individuals that are there. If you get these kinds of situations, there is no recourse to try to address it. I'm concerned about it. So I don't think this particular amendment was out on the subcommittee, but I don't think this amendment is ready to go forward without us meeting those challenges. And also looking at the fiscal impact if we do that, and looking at the past caseloads that we've had. I spent a lot of time trying to clean up disability and special needs. So please, don't give that agency more issues that they can now address as we try to clean up what's already there. Thank you, Mr. Chairman.
Thank you, Senator. And as always, and to each and every member, whether it's when a bill has been trusted to the committee or perchance a bill is already on calendar, you have an interest in amendment, research of any description, we stand ready at the committee staff level to assist. Further discussion?
Mr. Chairman.
Senator from Clarendon.
We can check the records or check the minutes on the mental health issue. I don't exactly recall what we did about it, if anything, but I think it came up several times. But the question I have is, so let's just assume that this bill passes this committee, and then at some point it will come to the floor of the Senate. And let's just assume that it eventually passes, and we all know it's headed to the courts. And my research has shown that similar steps have taken place in other states, and I don't see where much success has been had in the courts, but I do see where there's been a lot of unnecessary money that has been spent fighting these cases in other states. So I'm assuming that we're willing to do the same thing in South Carolina. As the senator from Richmond said, we have other agencies and other core responsibilities of government that we can't fully fund, but yet we're willing to spend money fighting this when, from all other indications in other states, I think just recently maybe Alabama, and they have not been successful. Just money going down the drain that could be better used for other functions of state government. I would much rather let the Alabamas and the other states fight it and spend their money than us trying to think, like I said in the committee, we have the magic potion, we can wave a wand, and lo and behold, when South Carolina goes forward, the courts are going to agree with us, because so far I think they have been consistent in not being successful in following these challenges or promoting or forwarding these types of bills.
Senator from Clarendon, you're stealing the Senator from Orangeburg's thunder. And he's got a page full of notes over there, I see.
Mr. Chairman,
Yes, sir. Senator from Orangeburg.
it's a question before us, the adoption of the subcommittee report which removes rape and incest. So basically what's being asked of us to do is to vote to empower rapists and child molesters to vote against victims. That's the question, then I call for the question.
Second.
There's further discussion.
Mr. Chairman.
Senator from Beaufort.
And I guess this is a procedural argument, but would the senator consider withdrawing that motion so that I can move to have the amendment that I've laid upon the desk debated? I think it would probably...
He would like to have a vote on the committee report. I don't think you're...
With no prejudice to you putting that up.
You're not trying to bring the discussion of the matter to a close. We're just trying to get a working document before the subcommittee, or before the committee. So let's take it to vote. We have the Senator from Richmond.
I think the senator from Beaufort still has an unread list. I understand what you're talking about.
Senator Beaufort, we will address, as I understand it, there's only one other amendment pending, and that's yours, after we dispense with the committee report.
I guess as a procedural matter, is it appropriate that we move first to vote on the bill as amended by the subcommittee, or is it appropriate to take up an amendment laid on the desk to further amend that report by the subcommittee, and then to take action depending upon what the outcome of that vote was? I just asked that as an open question.
Well, you drew your amendment to 3020 as the Senate received it. I don't think it matters that I presented it to you, deference and respect to the 7 members who served. Senator from Colleton, I believe, about at least 12 hours hearing from score or more of our, 4 of our constituents, representing all corners of the state, but I serve it. I will abide by the pleasure and will of the committee. We've had the previous motion for an adoption of the committee report. And we had the question called and
Call the
seconded.
question.
So
Discussion, can we have discussion on this particular
motion?
motion? And it's been seconded, and so now it's up for discussion, is that correct?
Well, he's calling for the question. We've actually he's actually wanting to have a immediate vote, and we really, by rule of the Senate, don't have a debate on that procedure. So unless he withdraws, we're gonna go to a vote. Senator Barnesburg insists.
I do, because we're gonna get to a vote anyway. I think everybody wants to go ahead and vote on this, so I'd like to go ahead and vote on this, and then we'll take up your amendment.
All in favor of adopting the subcommittee report, signify by saying aye. Aye. Opposed, nay.
Show of hands.
It's been asked for a show of hands. All in favor of adopting the subcommittee report, raise your right hand. All opposed to the motion, raise your right hand. Motion fails on a 6-9 vote. Senator from Beaufort.
Mr. President, Mr. Chairman, are we on my amendment at this point in time? Can I speak to it, or what's the proper way to put it?
Well, at this point, we are still addressing 3020. 3020 as a House bill reported to the Senate is still before the committee. The subcommittee report has been failed for lack of a majority. 3020 is still before us.
One word.
Senator Martinsburg.
So your amendment is now moot because the only bill before us is the House bill, which what your amendment would return this to. We don't need to adopt your amendment if what you want to report out is the House bill.
Well, so I think Senator Martinsburg, we need to allow the Senator from Beaufort to present his amendment because there is a
I
distinction.
think the amendment is a bit different.
Okay.
So,
I'm sorry. I thought it was.
So at this point in time, we have the bill as presented to us by the House under consideration.
Right.
And is my amendment, I'll ask staff, is my amendment properly drawn to that bill as passed by the House? Or is it only proper as to the bill as amended by the subcommittee, in terms of how it's drawn?
Senator Davis, Mr. Chairman, my understanding is that our legal staff drew that to the bill as we received it, which is the House version amended.
I inquired specifically of Senate Council just a minute before the meeting. Drawn to the bill, drawn to the House bill.
For purposes, I would like to move to have the amendment that I have laid on the desk considered and then discussed and ultimately voted on by this committee. So I would so move. The amendments, I will explain it, I guess, once.
From a procedural standpoint, it's before us, Senator. It was presented in due form and due order.
Should I explain it
It's-
before or
it's-
after it's seconded and discussion?
Well, it's been published. We're in the process of publishing the amendment,
Okay.
and it's before the committee. And like Senator from Beaufort,
I would-
proceed with an explanation of the amendment.
Okay.
Senator from Richmond,
Where's the copy of the amendment?
first page.
Okay. Yeah, Davis amendment.
First page behind tab 4.
Thank you, Mr. Chairman. I would like to explain the amendment. I think it's the first document that's in your book under tab 4, I believe. And would like to make some remarks. I don't have any prepared notes, although I've been making notes as we've gone along here. And I've been thinking about this particular issue a lot ever since I knew that we were going to have a full medical affairs committee on this date to take this up, because I wanted to be prepared to cast an informed vote, and I wanted to be able to explain, why I think the bill needs to be amended. First of all, I want to say that I am pro-life. I have voted for every pro-life bill, I think, that's been debated in the Senate since I was elected in 2008, and then even prior to that when I was the governor's chief of staff. And just making notes as I was going along here, I've supported parental consent notification, I've supported a waiting period, abortion counseling requirements, mandatory ultrasounds, a ban on certain sorts of abortions, whether it's partial birth or dilation and extraction. I consider myself to be pro-life, and I offer myself to you today as somebody who's pro-life and somebody who wants to see 3020 passed by this General Assembly and signed into law by Governor McMaster. I disagree with some of my Democratic friends in saying that that is simply a Pyrrhic or a academic exercise. I think it does make a difference when states pass bills that would constrain abortion to a greater degree than what was decided in Roe v. Wade back in 1973, and for the reasons articulated in Justin Blackmun's decision back then. I think that we've had 46 years of advancement of medical science since that time. I think that we know a lot more about this particular medical situation now than we did back in 1973. And I think it's entirely appropriate for state legislatures to pass laws that may be in contravention of Supreme Court precedent or stare decisis. I mean, that's the only way, as a practical matter, one of the primary ways that you get stare decisis or prior Supreme Court decisions reversed. And we saw that in the case of Plessy v. Ferguson and Brown versus Board of Education. I mean, when Plessy v. Ferguson, a Supreme Court decision announced the doctrine of separate but equal, and that children of separate races could be in different schools so long as they were equal, that was the law of the land. And laws that were passed by legislatures that contravened Plessy v. Ferguson were at that point in time unconstitutional. Yet they were passed in any event, and the reason they were passed is to provoke a discussion of the matter in the federal courts, and ultimately, hopefully, in that case, that the Supreme Court would accept on a writ of certiorari, or if there were a disagreement among federal circuits, that they would take the issue up again, which in fact they did in Brown v. Board of Education, and they reversed almost 100 years of Supreme Court precedent. And I think that we all think that was the right thing for the Supreme Court to do. I think we agree that Brown versus Board of Education corrected what fundamentally, I think history has shown to be an error by the Supreme Court of South Carolina in construing the Constitution. So I don't agree with my friends when they say that passing a state law that is in contravention of established Supreme Court principle is a Pyrrhic or a hypothetical or a pointless exercise. I think as a practical matter, that is really the only way that the Supreme Court can revisit an issue. The Supreme Court can't, in the abstract, just pass upon the Constitution. It has to have a case in controversy before it. It has to have something that is justiciable, that has to be adjudicated. And I think in this particular case, the only way you have Roe v. Wade and that 1973 decision reconsidered is by having legislatures pass laws that are in contravention right now of what was a clearly established principle. So I wanted to make that point from the outset. The second thing I would like to note is that even in states that have been the most restrictive in terms of curtailing or limiting or attempting to ban abortion rights, to my knowledge, there has always been, even in those most restrictive and conservative states, and I'm using that term loosely, have had an exception for the life or the health of the mother. Okay, I think that's a common theme you see running through this. And as I look at this issue, and as I try to decide, how I'm going to vote on this particular bill, I consider a woman who has become pregnant as a consequence, say, of a forcible rape, that forcing that woman to still have that child, at least in my mind, has the potential of materially impacting the health or life or well-being of that mother. And I realize it's not rising to the physical level that you're talking about. It doesn't put her life at risk. But there are certain physical and emotional and spiritual impairments and damages to her life that may occur as a result of that. And And I was struck by the Senator from Anderson's statement when he was reading it, by saying that abortion won't undo the violence or trauma of a rape. And I think I wrote that down correctly, and I was writing quickly. And that's true. But forcing a woman who has become pregnant as a result of rape, that does continue the violence and the trauma of that rape. Okay, so I don't think the inquiry is only, well, it's too bad that somebody became impregnated in that way, but abortion isn't going to cure that trauma. I think a reasonable argument can be made that you're perpetuating that trauma by forcing that woman to have the child that was conceived as a result of rape. And so, to my way of thinking, that the incest and rape exceptions that have historically always been a part of abortion constrainment bills until just recently, and I recognize that there is a new strategy or a new thought that's being advanced. I think that the reason they have always been exceptions is because they are inextricably tied to the health or well-being of the mother. And I think that's why they've always traveled together. And I think what we're attempting to do now is to say that no longer is somebody who becomes raped as a result of abortion of incest, no longer is making them forced to carry that child to term and give birth, that doesn't affect them at all. That doesn't affect their health, that doesn't affect their spiritual and mental well-being, and I just don't think that's true. I don't think that's true. And so I think that, in the way I think about this, rape and incest is inextricably tied to life of the mother. And even in the language that was read by our staff, by Jean, and I wrote that down as quickly as I could, I think that the language of 44-41-710B2, when it talks about the life or health of the mother, it does talk about prevent death, but then it says to prevent serious risk of impairment to a major bodily function. Okay? Is a woman's mental health a major bodily function? Is a woman's spirituality or the way she feels about herself a major bodily function? I think that it is. I think that it fairly falls within that particular exception. That I think everybody, even the Senator from Anderson and those who worked so hard on this bill, and I should have thanked you for the work on the bill for that. I do thank you for your work. Even they acknowledge that the health or well-being of the mother is an exception. And I just don't think that rape and incest should be divorced from that particular exception. I think that is a presumption that we're making that isn't borne out by life experiences. I also wrote down in the Senator from Anderson's opening statement about how we have certain unalienable rights, and among those are the life, liberty, and the pursuit of happiness, among those. The others, of course, are listed in the Bill of Rights, and we're familiar with those: the First Amendment, freedom of speech, religion; Second Amendment, right to bear arms. But even those quote-unquote unalienable rights, even those rights that we hold to be sacrosanct and should be set aside from the vicissitudes of democracy or action by a majority, even those have restrictions, okay? The First Amendment, you can't yell fire in a crowded movie theater. Okay, you can have your speech rights forfeited if what you're doing is going to cause or incite harm to others. The Second Amendment, the right to bear arms, that can be forfeited if you're adjudicated to be non-compos mentis or if you're convicted of a felony. So inalienable rights, yes, okay, they are inalienable rights and inherent in being a human being, but I think we all accept that those are subject to some restrictions. Even those are subject to some restrictions. And the First Amendment and the freedom of speech doesn't mean you can say whatever you want, whenever you want, and I think that most people would agree on that. So those two things that the Senator from Anderson read about how an abortion doesn't undo the violence of a rape or trauma, that's true, but it may mitigate the trauma going forward and being forced to have birth. In terms of inalienable rights, I think there's always a very strong presumption in favor of not letting them be infringed upon by the majority. But we have recognized and established Supreme Court precedent that I don't think anybody objects to, that those are qualified and those don't have unlimited application. I look forward to getting this bill passed. I look forward to being at the signing ceremony with Governor McMaster. I look forward to filing an amicus brief in support of this particular law as it works its way through the federal district court. And I support doing whatever we can to undo what I think was a wrongly decided decision back in 1973. Or actually, let me say differently, that the information and the knowledge and the science that is available to us now is materially different than it was in 1973. And I don't view this as being a pointless exercise. I don't view this as being a waste of the taxpayers' money. As a practical matter, I view it as being the only way in which you challenge stare decisis and prior Supreme Court precedent. So that is the reason why I would put back into the bill the exceptions for rape and incest. Now, I've been paying attention to the conversation throughout the country, and I realize some arguments that have been made is that, well, you're going to let the exceptions follow the rule. You're going to allow anybody to come forward and simply say, I've been raped, or I've had this pregnancy as a result of incest, therefore I get the abortion because here's an exception. And I recognize, I don't know if that would occur, but I recognize theoretically that it could. The way that I've drafted this amendment, and the way I think it differs from what the House passed, and correct me if I'm wrong, is that in order for a woman to claim rape or incest as an exception, that there would have to be empirical or objective evidence of that fact. And I have listed here a police report, and that follows what Georgia did. It provides sort of an objective indicia of the fact that this did in fact occur. And I do that in a way to acknowledge that, yes, sometimes an exception, inadvertent consequences, the exception can swallow the rule. And so I attempted to apply some objective criteria so that wouldn't be the case. And so I have thought this through. I have prayed on this. I have talked to my pastor. I'm a Catholic. I'm pro-life. I want to see Roe v. Wade revisited. Those are my public policy reasons for offering up this amendment. Now, I do want to shift to some procedural arguments. And I recognize that some arguments can be made that you shouldn't, base your decision on a bill based on its likelihood of passing, that we ought to be pure and that we ought to simply vote on what we think is right. But I would submit to you that procedure is important here, because just a couple of years ago, we were in the Senate and we were debating a bill, an abortion ban bill, that had rape, incest, and health of the mother as exceptions, and we could not get 26 votes for cloture to cut off debate and vote on that bill. I already know that if there is a bill on the Senate floor that does not have rape and incest as exceptions, you're going to lose votes that you had for cloture 2 years ago, and you might not even get 20 votes. And I'm not sure what we accomplish. And you talk about taxpayer money, and you talk about trying to advance public policy. I don't know what we accomplish by passing a bill out of committee without those exceptions being precedent, when we know, as a fact, that it may not even get set for special order debate, because the majority leader has announced that when he is going to set bills for special order, he wants to know that there is an end game. He wants to know at some point in time there can be a cloture vote and we can vote on that bill up or down. And I fear that, and I'm pretty certain that if we pass the bill the way that it is right now, without the rape and incest exceptions, it doesn't even get on the Senate calendar. It never gets set for a debate on the Senate floor. It never gets to a point where we can make arguments to the people of South Carolina and hopefully get a bill passed and signed by the governor that then advances this cause of having Roe v. Wade revisited. So I feel, for public policy grounds, and I feel based on those procedural grounds, that if you are truly pro-life, and that if you truly want to change Roe v. Wade, and if you truly want to go ahead and move things forward in favor of life, that this is the way to go. And that's how I've thought through the issue. I've gotten no marching orders from the Republican Party. I've gotten no direction on what to do. I've talked to my priest. I've talked to my wife. I've talked to my daughters. And I feel comfortable with the position that I've taken. Thank you, Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
Before we have debate, let's get a formal endorsement. Senator from Berkeley, you second this.
I second the motion.
Come to Senator from Orangeburg and back to Spartanburg.
2 questions for the author of the amendment, please. So, I heard you say that you thought that passing this bill, which codifies abortion on demand, is the only way to challenge Roe v. Wade. Why not just saying, back to the personhood bill, that it is illegal? I mean, it seems to me that what you're asking this committee to do is to codify abortion on demand. Say it's fine in South Carolina up to 8 or 12 weeks, that's fine. It is absolutely the law of the land. Why is that the way that you would challenge a bill, rather than just go ahead, if you want to challenge it, just say that South Carolina's not going to allow abortion?
Because I guess as the former president of the Senate once said, President McConnell, there's no education in a second kick of the mule. And 2 years ago, we had that debate on the floor of the Senate. And you made a persuasive argument at that time, and we went ahead and accepted that particular challenge on your behalf. And we debated the bill, as I recall, for at least a couple of days, well into the night, and took multiple cloture votes. And I think the high watermark was maybe 25. I don't recall exactly. And that goes, I think, Senator from Orangeburg, to my second point, is that I don't want a pyrrhic victory. I don't want to pass something that is as pure as possible. I want to pass something that has a reasonable likelihood of being passed by the Senate, overcoming a cloture vote, that gets concurred with by the House, in which, by the way, the House voted overwhelmingly to have rape and incest as exceptions, and that it gets sent to Governor McMaster, and that we can have a bill signing, and that we can all join forces to try to get that through the federal judiciary process. So I understand what you're saying, but in terms of the arguments that I made, the public policy arguments I made, I gave the reason why I think rape and incest should be in there for public policy reasons. I believe that's inextricably bound to the health of the mother, and I realize others may differ. But I want a bill that passes, and I want a bill that gets signed by Governor McMaster, and I want a bill that we can go proudly defend in the federal district court. And I view this as the best way to accomplish that objective.
My second question is, are you, by your amendment, saying you don't believe a woman who's been a victim, you got to have a police officer vouch for her before you'll take her word?
I thought a lot about that, and I researched what other states have done, and I researched the arguments that were made against the sort of amendment that I'm offering. And some of the arguments that were made was that these exceptions could be abused. And they could be abused, at least in theory, to the extent where the exceptions follows the rule. I'm not saying that as a practical matter that would occur, but I am willing to acknowledge the logic of that argument against these exceptions. And in an attempt to mitigate that logic or to overcome that argument, I have put in the objective verification and to have a third party attest to the fact that a crime has occurred. I think Georgia did that. I don't think Alabama did. But in my judgment, in trying to figure out a way to answer concerns that are expressed by those that are concerned that the exceptions in regard to incest may swallow the rule and there may be absolutely no curtailment of abortions whatsoever, I made the judgment in terms of drafting this amendment to require that objective empirical evidence of that fact. And I realize that others may differ on that.
But the final point, I guess, is the bill, as it came out of the House, did have the verification that you had to tell the doctor. And now you're saying that's not good enough. You got to tell the police officer, which by definition of what I understood your concern to be, the trauma to the woman who's already been traumatized, to put her through, to have to go through the whole, everything that follows you making a police report and you having to go through all of this and tell all of these other people, when you could have just talked to your own doctor. You could have handled it in a way that's least intrusive given the bad thing that's already happened to you. Now you're requiring the victim to open up to the world something that's foiable, that's, you know, it's in the public record, you go make a police report. That's the way you think that you minimize the mental health of the victim?
That's the way I think that you mitigate the concern that the exception might swallow the rule. And I realize that the threshold of quote proof unquote that is in this amendment is higher than the one that was in the House, which is why it's different from the one in the House. And I recognize that police reports are foiable. I recognize that there's potential of embarrassment or there may be some reticence to file a report. I understand that. What I attempted to do, Senator from Orangeburg, was to articulate the public policy reasons for the exceptions for rape and incest, and then I tried to go ahead and provide assurances to skeptics that this would not be an instance where the exceptions follows the rule. And I understand that we could have a difference of opinion about whether or not that, is fair to the victim, whether or not that promotes that public policy. All I can share is what my reasoning was.
Now, the difference of opinion is some of us believe women and then some people don't.
I understand.
Thank you, Mr. Chairman. Senator Buford. My question for you is, this amendment that you proposed today, since what the subcommittee did was effectively knocked out, this is amending the bill as passed
By the House.
by the House. So this makes it tighter than what the House passed, correct?
To the Senator from Orangeburg's point, I believe the House version simply had position verifying that occurred. This particular amendment would require that third-party objective proof in the form of a police report. And again, I recognize the point that Senator from Orangeburg is making. What I was attempting to do is responding to criticisms from those who don't want the exceptions and having them say that you're going to have an instance where the exception swallows the rule and you're simply going to have everybody traveling under those exceptions. I recognize the merits of what Senator from Orangeburg is saying, but those were my motives for putting that criteria in there.
Thank you.
Senator Clarendon, then Richmond.
Thank you, Mr. Chairman. As I said earlier, over and over again, all of these situations are different. And, until we walk a mile in those shoes, we just never know what it feels like. And so to say that we're going to require a police report, it sounds simple, but there have been a lot of very highly publicized, highly profile cases just recently where women are coming forward now that were raped years and maybe decades ago, and they didn't report it to the police. It's when you're in that situation, and if you're raped by somebody, it's not easy sometimes to file a police report. You have to look at the fact that some of these ladies who are raped, they file a police report, they fear for their life. Sometimes they are powerful people, they fear that their career may be ended. A lot of situations that I've read about just recently with people who were raped years ago and coming forward now and saying why they did not report it when it occurred. It's not very easy to do. And doing the subcommittee testimony, we had such a case where I was reminded a woman testified that she would actually commit suicide if she was forced to have a child that was conceived by rape, and that she also would have a very hard time reporting to the police because the rapist knew her and knew where she lived, and she feared for her life. So I understand the point you're trying to make, but for a woman who was raped, filing a police report sometimes is a lot easier said than done, because there's so many other things that come into play that, again, we, except Senator Wright Matthews, would never have to experience directly.
Senator from Richmond.
Thank you, Mr. Chairman. Senator Buford, just a couple of questions on the police report. There are times when individuals will get with the police department to file a report, the report is not filed, simply because time has passed and either the police officer doesn't believe the report. The other question is the time element, especially with date rape, drugs, and all kinds of other things that occur, and then time has passed and then the person discovered that. My real concern with the police report doesn't have any ability to do any form of examination unless let's say physical proof that the person is injured, and that still doesn't dictate that's a rape. I'm a little more comfortable with the doctor doing the testing, and as was indicated earlier today, there are other new, and I think you made the point of other new scientific ways of doing some of the testing. But I'm just not comfortable with the police report for this reason as well. An officer could have been involved himself. The officer could have known somebody who, in fact, have created this crime. So I'm just not comfortable with the police report in it.
Just
Briefly, by way of response, the amendment doesn't speak to what needs to be included in the police report, physical examination, things of that nature. Just the fact that a police report has been filed alleging rape. And again, it was an attempt to have a third-party indicia of the fact that it did in fact occur. It's not going to be perfect. But again, I'm trying to respond to the criticism of those who are afraid that if you create these exceptions, that they're going to swallow the rule and defeat the purpose of the heartbeat bill in its entirety. So I can just, I take your point, but that was the reason for the phraseology.
Sir,
Thank you. I wonder how many of us on this, sitting up here, have ever had the chance to defend an individual who's been charged with a sexual assault, rape, or anything like that. If you had, then you would understand. That's part of what I do. 40% of my practice is criminal defense. And in that, you would, and I know that Senator Hunto also does it, and a couple, I think that's it. If you ever defended a CSC case, you would then know the protocol that is required by a police officer when a person comes in and complains of a sexual assault. Now, I know it from both ends because I've also defended people who were, or either presented claims for people who have been sexually assaulted. Because the protocol for a woman is something you can't imagine. You don't just walk into a station and get a police report. It's very far from that. You gotta go through buccal swabs. You gotta go through a sexual examination. They have to make sure that you're hymen. And let's get it real now, because we haven't had this before our subcommittee. And that's one of the procedural problems I have. There's a lot that a woman goes through, and my God, you have to, and let's say it happened in Walterboro. You might have to go from the police department or the sheriff's department to the hospital, and hopefully they have somebody there. If not, then you need to go to MUSC. Okay? We're talking days. Then you have to go through a psychological evaluation. My God, if you are a child, it's a little bit different. Not only will that officer have to escort you, but someone from DSS or another agency then has to escort you to, say, Beaufort to Hopeful Horizons, and you have to go through the video process, plus you have to have the physical exam to verify that you have actually filed this report, because they've got to follow up. My point is, you're going to get probably some of the, and I know you've thought through a lot of this, but it's not as simple as just putting it in here that a police report.
Let me respond to that if I could, because it is. Because you're right that these are things that all occur subsequent to a police report being filed, because those are things that need to be gathered in order to successfully prosecute the crime that's been alleged by that filing. This particular requirement speaks only to the filing. Initially, and I have been involved in the defense of rapists. The police filing is a filing, okay? That is an objective indication that a crime has been alleged. What you're referring to, Senator Colleton, are the things that are subsequently done by law enforcement and by prosecution in order to develop the facts and the evidence in order to successfully prosecute that complaint.
No, I'm
Okay,
referring, I know I might have made it a little difficult. That's not all I'm referring to.
Let me finish. This particular amendment speaks to the filing of a police report, okay? What you're referring to are the things that are then done subsequent in order for the police to develop a case that can be successfully prosecuted. That's not what this amendment speaks to. This amendment speaks to the actual filing of the report with the police department, which does not involve all the things that you referenced. It does involve all those things if the person complaining of the crime is hopeful of being successful in a prosecution. But let's not confuse that with the act of the filing, which is what this amendment requires.
What I'm trying to say is you can't separate the two. What I'm concentrating.
But I've done separate the two.
No, you have done it.
Yeah, in the bill.
But you don't understand.
Yes, I do.
There's a responsibility as far as police officers that a protocol is not, once you report something such as this, they have, the state then undertakes the responsibility to proceed with processing and following its protocol. You can't just walk in there into a police department and say, hey, I've been sexually assaulted by this Joe Blow, and but I don't want him prosecuted. That's not the way it
No,
works.
and I take
so
I take your point.
what I'm
and I-
on is saying that what is happening, and I think you misunderstood me. I'm saying what happens to the woman
Once they
in
file.
this, once they file. I don't think that has been clearly evaluated by this committee. And that is important because you're the one that have said, and I totally agree with you, that we have to think about the mental effects of what is going on with the woman. So by putting that in there and not as an additional requirement to her reporting it to her doctor, first, I see a big delay that will likely occur. And second, I see the mental and physical effects of what is going to happen to her, because especially in small areas and especially on college campuses, people can get, it becomes, once you go to the police, and it becomes public, whether or not you like it or not, and that adds to the mental harassment, mental and psychological effects. I mean, just put it into a college campus, or say in a Walterboro, or into a Allendale. Put it in those small communities. As soon as somebody goes into a police department, everybody knows about it. What does the woman feel? That should be up to her and her doctor, is what I'm saying. And so we just don't necessarily.
I take your point. The only point I was trying to make, so Carlton, is this amendment only requires the filing. And my point that I was making was what you're describing are all the things that subsequently have to be done in order to successfully prosecute an alleged offense.
I'm saying that it's
Okay.
no such a thing of only filing criminal sexual conduct. Once it gets filed, the state undertakes it
I understand.
and is going to make the woman follow through with those evaluations. It's like a criminal domestic violence. Once you pick up that phone and you're fighting with your spouse or significant other, and the officer comes to your house, it's not your call on whether or not the state will, whether or not your spouse is going to be prosecuted. It becomes a responsibility of the state, and the state undertakes that, and you can't dismiss it, whether you like it or not. I'm just saying,
I take your
the
point.
practicality of filing a report when in criminal sexual conduct to protect victims. There's a victims. You were a part of the governor's office when Governor Sanford passed that Victims Protection Act. That's why you can't proceed. You can't just file a report these days, and that's a good act.
The only thing I would say to close out this particular colloquy, and I take your point, if they're good ones, is that this is not a novel thing. Georgia has done this, other states have done this in an attempt to provide indicia or objective verification so that exceptions don't swallow the rule. I take your point, but that's the reason for the inclusion.
That was an 8-point counterpoint exchange colloquy, and appreciate the maintaining decorum. Thank you both. Senators from Spartanburg, then Charleston.
Thank you, Mr. Chairman. I just want to make sure that the committee doesn't get lost in what we're talking about now. Go back to the merits of the bill. We've got a child who was conceived and the life began at conception. And they're sentenced to death when any of this goes. When abortion takes place, that child is sentenced to death without due process. So I just don't want to let that get lost on the committee. So, Charles, thank you.
Mr. Chairman, thank you. While I appreciate with the senator from Beaufort, the amendment that he has offered, Senator, you can't put lipstick on a pig. This bill is still a pig. You're denying a woman's right to choose. Now, I know it makes y'all feel a little more comfortable. Everybody wants a prize for doing away with some exceptions that are really personal, rape and incest. But there's a fundamental, well-documented right for women to make a choice for these difficult personal decisions. Now, Senator, we got, I counted, 14 men up here and one woman. These 14 men are now going to come in the medical room. Did you know the bill requires very strict protocol? Did you know? For the doctor to meet the heightened burden of trying to explain why this woman can have an abortion because her life is at stake. Did you know now we're going to call the police? We're going to call the police. It's tragic enough that these women are going through a tough time to make a personal decision. Got 14 men, one woman, analyzing doctor's notes and reading through a police report. Now, Senator from Beaufort, I appreciate your analogy to the plethora of desegregation cases. And we're going to walk through those cases on the Senate floor, and I'm going to offer a different opinion. I do not believe that the appeals in those cases have any analogy to what's at stake before us. Number one, and I got the most recent orders from the court dated, the most recent dated October 29th from Alabama. Women don't even know, in most cases, that they're having a baby at 6 weeks. Black family knows they're having a black baby. So the medical background outlaid in these cases where the plaintiffs have had to make out the elements of a preliminary and temporary injunction are not directly on point with desegregation cases. But most importantly, and to your point, that we all of a sudden need to do this so we can get up to the Supreme Court, I don't think that's accurate. And Mr. Chairman, if I might just read, I know I'm not supposed to read, but the senator, I didn't know about this police report amendment. So I was not prepared to deal with it, and I want to read from it. Alabama all-state research that the Senate staff was kind enough to send to me last night. I was trying to get my kids to bed, so I didn't have a chance to read it. But, Senator, there are a lot of cases right now that are headed to the Supreme Court. We don't need South Carolina to make a point in the Supreme Court. October 29th, I believe that was last week. Federal judge issues preliminary injunction blocking Alabama's nearly complete ban on abortions. October 1st of this year. Federal judge issued a preliminary injunction blocking Georgia's law, banning most abortions once a doctor can detect a heartbeat. That's the same bill. August 27th, federal judge issues preliminary injunction blocking Missouri's anti-abortion law. July 24th, federal judge issues injunction temporarily blocking Arkansas's anti-abortion laws, including one signed into law in March that would prohibit abortions beginning at 18 weeks. That's different. July 3rd, federal judge issues preliminary injunction blocking Ohio's anti-abortion law. May 24th, federal judge issues preliminary injunction blocking Mississippi's fetal heartbeat anti-abortion law, same law. May 29th, Louisiana governor signs into law ban against abortions where fetal heartbeat is detected. But the ban would only take effect if the federal appeals court upholds a similar law in neighboring Mississippi. April, federal judge issues preliminary injunction blocking Utah's law. March, Kentucky governor signs anti-bill banning abortions upon the detection of a heartbeat. That law and another anti-abortion law were temporarily halted by the court. Now, this is just preliminary research done by a law clerk last night. And so now we're going, if this bill passes, and I think you probably have the votes, if this bill passes in the committee, I think you probably have the votes. I just want to make sure that the people of South Carolina know, while I applaud the senator from Beaufort, and he and most of you work well with your colleagues, I got to say, we agree on a lot of things, Senator, particularly with respect to protecting our communities from toxic and hazardous exposure. But we disagree on this. This is nothing more than lipstick on a pig, and I refuse to out-wild hogs in a swamp. And therefore, I will be voting no.
In counterpoint, Senator from Beaufort, I got others.
Appreciate the points that Senator from Charleston make about how there are other states that have passed fetal heartbeat bills, and that how South Carolina doing so may be redundant. What that fails to recognize is that one of the criteria that the U.S. Supreme Court uses to decide whether to hear a case is whether there are conflicting decisions in different circuits. Okay, they can accept writ of certiorari, okay, they can do that. But one of the grounds upon which they will adjudicate a dispute is if the two circuit court of appeals have reached different decisions on a similar bill. Okay, so the fact that there may have been denials in Kentucky or Georgia and Missouri or Arkansas and Utah, that doesn't mean that we're going to have one in regard to our bill. That doesn't mean we're not going to have the Fourth Circuit make a determination. That doesn't mean that the Fourth Circuit's determination may be in conflict with another circuit's determination, which then gives rise to the Supreme Court having to come in and adjudicate that difference of opinion between two circuit courts. So the fact that there is a multiplicity of laws that are under appeal, that's beside the point. That's agreed. That's a red. In fact, that is one of the ways you get something before the U.S. Supreme Court is when you have Circuit Court of Appeals making different decisions on materially similar laws. And so far from being duplicitous and an empty exercise, it is one of the ways in which you get a matter before the Supreme Court for adjudication.
Senator Anderson.
Sure. Senator from Beaufort, I'd like to have a conversation with you, but first I would like to ask Gene, I believe a question was asked in subcommittee about the other states that have passed fetal heartbeat bills, which of them have an exception for rape and incest, and which of them did not have an exception for rape and incest. Did you an answer to that.
Yes, sir. I'm sorry you didn't get, I emailed that out to the committee, but I did bring a hard copy with me this morning just in case. And while I charged NCSL to be very thorough with the information they sent to us. I count six states that have essentially no exception for that.
So 6 states passed the fetal heartbeat bill without exceptions for rape and incest, and Georgia passed it with an exception. Is that an accurate?
I believe that's correct, Senator.
Okay. Senator from Beaufort, I appreciate and applaud your study, your prayer, your conversations with others, putting forward your amendment. And I find parts of your comments, as you found parts of mine, things that I could agree with, and I want to dig a little deeper into the areas where I think we diverge. One is that I certainly agree, and I think anyone that agreed with my amendment, that a woman's life is altered, certainly by the rape, the incest, and even further, if she becomes pregnant and has to carry a child to birth as a result of that. I don't think anyone will say, no, it's just no big deal and there's no possibility for further trauma as a result of that. I don't think anyone would take that position, and I don't think you're saying that we do, but you did raise the issue, so I just make it clear that yes, of course, I understand it would alter a woman's life. Of course, I understand there could be further repercussions. But Senator, I think you probably understand also that there are likely spiritual and mental and emotional repercussions that result when a woman chooses to allow someone to kill her baby. That those repercussions might very well follow her the rest of her life as well. I'm sure you've read enough about this to where you know that there are lots of women who have lots of problems for a lifetime. Guilt, shame, thinking constantly about the baby that was killed. So I'm not going to try to say, well, which is going to be the greater trauma here. I do want it to be said that it's not as if the abortion is going to erase the trauma of the rape, but the abortion might entail its own trauma. So I think there's a balance there. Now, I think the main place here that I get to a point of divergence is, what about Rebecca Kiesling? And what about Ashley Lawton? Women who themselves were conceived in rape, because I think you are, and I am, trying to say, is there a way that you balance these rights, the right to life, which I think is the greatest right, we hopefully would all agree, and the right to not have a pregnancy forced upon you, and all the ramifications that might go with that. I don't think anyone's saying that well, this is not a big deal. It is a big deal. I'm simply saying that if I'm Rebecca Kiesling sitting here speaking to you, now it's a different subject, because you're telling me that I didn't have a right to life. You're telling Ashley Lawton you don't have a right to life. You were conceived in rape, and I'm glad you're here, but you didn't have an unalienable right to life as I did. That is where we diverge, because that is, in essence, although I'm certain that you don't intend to say that, that is the end result of your exception, is you have removed the unalienable right to life from a human being's life that has already begun. In the case of this bill, the heart's already beating. So if I've got to weigh those two things, the right to life is always going to sink heavier in the balance. It is the greater right. It is the preeminent right. Now, you spoke also about important rights, such as the free speech right, the right to bear arms, that these rights have restrictions, and I think we all agree that you're accurate in that. But again, let's drill a little bit deeper in the subject. We're talking about the right to life. We're not talking about whether I can yell fire and a theater. We're not talking about whether I can own a tank. We're talking about whether I get to live or not. Now, I will back off that a step. After life, we're talking about liberty, right? Well, let's consider the right to liberty right now. Would there be an exception in your mind that would allow you to enslave another person and treat them as property? Or would you simply say there are no exceptions, there is no circumstance in which I would have the right to enslave another person and own them as property, because liberty is so fundamental to life that those two things can't exist. And I think life is even greater right than liberty, because if you don't have life, you don't have anything. And so I just simply say that, yes, there are restrictions on fundamental rights. No one disagrees with that. We're disagreeing about the right to life, though. I'm telling Rebecca Kiesling and Ashley Lawton and others, many of whom probably don't even know that they were conceived as a result of rape or incest. Their own right to life just doesn't exist in this circumstance. I want to move on to your third point, which I also think is a good point. And that's the point about, well, what are we accomplishing if we put a bill out there and we can't pass it? The practicality of the whole situation. If we put a bill out there and it doesn't have exceptions, it's not going to pass. Well, first of all, what can it pass? It's passed in 6 other states. Or so we're just saying that it can't be done in South Carolina. 6 other states have passed fetal heartbeat bill with no exceptions. Why can't it be done? Why not bring the bill to the floor if you believe that a human right is inalienable? Why not bring it to the floor and let people have to vote on that and be on record? I've said it's a hard vote, it's an uncomfortable vote. I've acknowledged all that I can, and I'm willing to acknowledge more, that this is no easy decision. But there's not going to have to be a decision if it doesn't get brought to the floor of the Senate for a vote, and people have to take a stand and say, I believe this right to life is the preeminent right that trumps all others. And so I say, yes, let's push the envelope and see where we get. You're not going to get anywhere if you don't push the envelope.
Can I respond? I don't want to interrupt the senator.
Well, I want to say one last thing, getting back to what the senator from Orangeburg said, and that is this. Everyone in this room knows that I'm a proponent of personhood. That our laws should recognize that you should be legally recognized as a person and defended by the 5th and 14th Amendments from the time your life begins. That, I think, is the key to overturning and actually challenging Roe v. Wade. In Roe v. Wade, they simply told Texas, your law is self-contradictory. You're in here claiming that this is a person in the womb, and you got exceptions in your law. You can't have it both ways. If it's a person, then you can't have a clause that just allows an innocent person to be killed. You're contradicting yourself. And so, Senator from Orangeburg, in a sense, I appreciated your amendment, although you know that I didn't think it went far enough, because your amendment to the bill a few years ago included exceptions for rape and incest, whereby you're denying a class of people their unalienable right to life. And so I made it clear that when you put that up, I wasn't going to vote for it. And so I will simply say that this isn't the best bill even to challenge Roe v. Wade. But if you're gonna put exceptions in it, if you're gonna say we're gonna protect everyone who has a heartbeat except for these classes of people, I think the Supreme Court's gonna say it doesn't make any sense in South Carolina. So that's my response to you. And again, I appreciate your thoughtfulness and your willingness to engage the dialogue.
Senator's response, and then 2 more senators.
First thing I'll say is, the senator's argument would have merit about why not push this forward to a vote if we had in fact just had a vote on this very thing. And I think that we would be derelict in our duties as senators to not recognize what the result of all that was. Okay, so it's not like we haven't had debate, it's not like we haven't had votes, it's not like we don't know where they stand on this. The second thing I will say, in regard to the argument that we're being inconsistent, as I stated earlier, even the most restrictive anti-abortion laws have always acknowledged the exception for the health or life of the mother, okay? So there are bills, even in those most conservative jurisdictions, that authorize the killing of an innocent life. Okay? You kill the innocent life of that baby because of the effect it's going to have on the mother. And that's why I have attempted to explain the reason for these exceptions is I believe that being raped or being impregnated as a result of incest and the impact that has on a woman's well-being and health, spiritual, emotional, physical, I think that is consistent with exceptions that have long been recognized and long been acknowledged, and I do not think, and I'm prepared to argue about how that's not inconsistent with what we have decided in the past in the Supreme Court and in states.
So, Collins.
I just have a quick question. Maybe I'm not sure who should answer it, because it seems like what has been proposed in your amendment basically gives us a big conundrum, because in looking at it, I read over it again after we had that back and forth. So, say we have someone, a young girl, she hides it because she's so embarrassed because it's a family member that has raped her. So if she goes in and finally her pregnancy is seen by her parents, and she's in the second trimester, and then it's reported to the police, as you're requiring, as well as the doctor after they've confirmed. So not only do we have something that would that under your bill, your amendment, excuse me, to the bill, would she then be permitted to have an abortion?
If there was a police report filed, yes.
So that is a big conundrum, wouldn't you agree? Because that extends the time for having a lawful abortion beyond what we have in place today. You don't see that as a conundrum?
In regard to what, in what you're referring to Roe v. Wade?
Yes.
No, because in Roe v. Wade, as you know, there are
Yes.
3 trimesters, and in the first trimester, there is a virtually, free discretion.
Right.
In the second trimester, it's with the advice and counsel and the assistance of the doctor.
Right.
And then as you move through that continuum, it's the third trimester where the state has a compelling interest in the interest of that child.
So what happens then?
Let me just finish. In your hypothetical, if you're talking about taking it up to the 6th month
Yes.
of pregnancy, you would not be impairing what is already allowed under Roe v. Wade. I guess the argument that you're making is if you go into the 7th or 8th month and you file this report, that this particular amendment would allow an abortion in situations where Roe v. Wade authorizes, doesn't require, but authorizes the state to have a complete ban on abortions at that time. So it's not inconsistent with what we're passing here. It would be inconsistent with what the Supreme Court said in Roe v. Wade a state is authorized to do in that 3rd trimester. They are authorized to completely ban. But your point is well taken. This would, and I would say this would, if you are a woman who is impregnated by rape or by incest, and if you file that police report, and if you make that report, that under this law, this state law, that she would be allowed to have an abortion at that point in time, subject to whatever prior constraints that we may have passed in regard to the method of abortion and to whether the physician has to be attended, anything else that we may have passed. And I'll be honest with you, I don't have a list of the other restrictions or requirements that we've imposed.
But it does significantly expand the time frame of the fetal heartbeat bill, beyond, say, when the heartbeat would be.
Well, yes, because that's what we're talking about here. We're talking about exceptions to the heartbeat bill.
I'm saying the conundrum is that this expands it back to where we were under Roe versus Wade.
Right.
Because.
The whole purpose of these exceptions is to say that you're not constrained by the heartbeat period, that you can then have the abortions outside that. That's the point of this.
Yeah, and we heard a lot of people that, I heard them in personhood, as well as people that came before the subcommittees. And I even gave a little testimony myself, because in all of my 4 pregnancies, to be honest, I didn't know I was pregnant within those first 6 weeks. And so I think it's sort of difficult to imagine a situation where, especially here, where you're going to have the protections that you say that you want. I think it's a good idea in your head, but in actual working it through, I don't think it's going to work the way you want it to work. Especially another issue that I'm going to readdress again, and I want you to consider it before formally presenting your amendment for adoption, is in a situation where the senator from Orangeburg talked about, where someone, say a young child, reports an incest or an assault by her doctor, to her doctor, there the doctor's under mandatory report. Have you considered any of that in your amendment, and whether or not you want to then make the mom and dad, or make the child, have the responsibility before that child can get the abortion, to then have to report it?
So let me ask this question, and this is all honesty, I'm just not thinking this through. So, and maybe the Senator from Warrensburg can help me. If a child is under a mandatory requirement to report to whom?
Mandatory.
To whom?
Authorities.
Okay, so then your satisfaction of filing a police report has been met. Okay, because if a child goes to a doctor and says, I'm impregnated as a result of incest, and if that doctor is under an affirmative duty to then alert the authorities, that then triggers this particular exception because there's a police report filed.
I think you take it one step further. So what happens then when the police come in? So when they understand that this is going to happen, you know what's going to ultimately result? They're not going to report.
But I thought you just said that the doctor has an
The
affirmative
doctor
duty to
has
report.
to, I'm saying the girls are not going to report.
Okay, but it doesn't say that the girl has to file a report. It has to say that there is
A police
official police
report.
report has been filed. It doesn't say by whom. So by what you've just stated, if a child goes to a physician and reports becoming impregnated as a result of incest, and if that physician is under a duty to notify the authorities, then you have satisfied the requirement of this filing of a report. It doesn't say filed by the child. It says file a police report.
And once it's known what they'll have to go through, once the police get involved, then you'll have a chilling effect regarding reporting and taking care of the child, is what I'm talking about. But that's not a here nor there. I guess you'd have to be a part of it. It's not as easy as writing it down, putting that there, because you have to think it through.
Well, there has been the Davis Amendment is on the desk, it's been seconded, we've had discussion. I'm asking, if there's no further discussion, that we consider the adoption of this amendment by the same manner with a show of hands.
Mr. Chairman, this would be an amendment to the House bill that requires only a physician, and this would require the filing in addition of a police report. Correct.
That's correct.
Mr. Chairman, so basically what is before us now, we have 2 choices. Vote for this amendment or accept the House bill as sent to us. At this time. At this time.
That's correct, at this time. Seeing and hearing no further discussion, I'll take it to the matter to a vote, take the amendment to a vote. All in favor of the adoption of this amendment, signify by raising your right hand. Opposed, like sign. The adoption of the Davis Amendment carries on a 9-6 vote. Matter before us now is H3020 as amended. The Davis amendment. Is there further discussion on the matter? Seeing and hearing none, we'll carry the matter to a vote. Same manner, show of hands. All in favor of a favorable report of the Senate when we convene in January, signify by raised right hand. Opposed to the motion, same sign.
Mr. Chair,
Motion carries 9-6. Senator Colleton.
were there any proxies, and if so,
None were presented to the desk.